Welcome back to Alberta Primetime and our Wednesday crime panel. Calgary's police chief is on a mission to root out officers who leak information to the media. In a recent publication of 10-4, the Calgary Police Association magazine, the editor and director of the police union said he supports the chief's stance on the issue, stating, "It disgusts me that one of our own members, sworn or civilian, would choose to make such a selfish decision. Currently, any members of the force who leak information to media without authorization are disciplined and could face termination." Jason, you spent a huge part of your career covering the police beat. What's your read on the conversation playing out here?
Well, my first message to Chief Chaffin would be good luck with that. You've got an organization of 2,100 individuals, and I have a lot of respect for the chief. I think he's been great in the time that he's had on the job. I think he's misguided here. You know, from a personal perspective, my success and longevity on the crime beat in Calgary depended in large measure on confidential sources, and I think Paul Wozni of the police union is really misguided when he characterizes anybody who leaks information to the press as somehow being disloyal or maybe being a bit of an attention seeker. You know, not all leaks and not all leakers are created equally. And, you know, a lot of times the confidential conversations I was having with sources was to try and confirm sensitive information that I may have received outside of the police realm. And I'm going to somebody in authority who's in a position to know, who may be able to tell me whether that information is correct or whether it's incorrect. So yes, I need something, but you know what? There's also an incentive, and there's also an upside there for that person on the other end of the conversation to confirm or deny what I'm hearing. Because you know what? If incorrect information comes out in the press, yes, it's the media's fault, but it can have a ripple effect on the police. So a lot of times there was an incentive among my confidential sources to make sure the right information was getting out there. I think that's a far different kettle of fish than somebody who either carelessly or maliciously leaks sensitive information that shouldn't come out, you know, so-called holdback information, stuff that's withheld from the public for investigative reasons. So I think the chief and the police union are really tarring a complex and nuanced issue here with a very broad brush, and I would hate to see somebody who's actually maybe doing some good by going to the media, you know, have their job placed in jeopardy, because it's not the same thing as somebody who's betraying the organization or betraying a confidence. Okay, so Greg, I'll put this question to you. At what point should officers face consequences for leaking information?
Well, obviously, if an officer is compromising an investigation, if there's something that's ongoing, if it puts officers' safety at risk, if it jeopardizes sources' information, then certainly that's something that police officers need to look at, and the force needs to pen in. You know, the problem you have with this particular case is the information that was leaked was with respect to the identity and the fact that this particular officer who was on duty had shot and killed not one person but two people. And
been involved in two shootings, one fatal, one also
correct,
fatal.
right.
Yeah.
So the difficulty is and it brings it back to the original, really the inception of this is why is this information not released? Can you think of any other situation in which someone can shoot two individuals and not have their identity released and be put back on the job? I mean, it's really a very poor policy decision on behalf of CPS to suppress the names of these officers. It undermines public confidence in the police department, and I simply don't agree with that sort of policy mandate.
Frank, as a former Information and Privacy Commissioner, how do you look upon the situation?
I'll pick up on what Greg said. Police society, police culture is a very, very closed, very tightly ordered subculture, and it has very strict rules about how rats or informants within the police service are dealt with. This raises a question, and it's exactly what Greg was saying, is where's the ability for genuine, legitimate whistleblowers in the police service? And I think there is a place for that. As Jason said, you don't want to risk lives, you don't want to risk officers' lives, you don't want to jeopardize investigations. But I don't think any organization should be so airtight that no air can get out either. And sometimes maybe there are things that have to be said. in any organization, there are things that are done badly, things that go wrong, things that aren't pursued that should be pursued. And it's already pretty locked down as it is in the police service. I totally agree that sometimes there is a need to go outside the channels.
Okay, so from leaks to the media to reversing the flow of information, Vice Media has been court-ordered to provide RCMP with information used in stories on suspected terrorist Farah Sheridan, originally from Calgary. He raised international concern after traveling to Iraq and Syria to fight with ISIS, where he released this video.
This is a message to Canada and all the American Tawagheet. We are coming and we will destroy you.
It was back in 2014. Vice published 3 stories based on online conversations between a Vice reporter and this individual. And it's the screen captures of these conversations that RCMP hoped to obtain. Vice currently considering an appeal of that decision. Greg, reporters protect their sources. That goes without saying, but how much of a leg do they have to stand on?
Well, I mean, unlike what a lot of people in the general public think, conversations with reporters are not protected in law. Conversations with reporters are not protected in law. Conversations with your priest or pastor are not protected in law. Conversations with counselors, with doctors are not protected in law. The only conversations that are protected in law is that with, happens to be that and your lawyer, and only for certain purposes, really in anticipation of litigation. So really the privacy that you have with respect to these conversations, whether it be a reporter or your pastor or your priest or a counselor, is really you put a lot of faith in the hands of the person that you're speaking to. So it really falls on the integrity and the personal values of the journalist that you're talking to. So at the end of the day, if these people are compellable, I've had cases in which journalists have been compellable. In fact, one of them is sitting here right beside me. We had a case in which Mr. Van Rassel was compellable as a witness, but didn't give up, to his credit, any of his sources in that particular piece of litigation. But that being said, yes, the only thing that's really protected in law is conversation between a client and his solicitor.
Okay, so Jason, when do you fight it? When do you comply?
Yeah, this isn't a hypothetical question for me. The Canadian Association of Journalists has a code of ethics that talks about protecting sources. And the bottom line is at the end of the day, it says that we still do have an obligation to the public. So if a reporter was sitting on evidence, that could make or break a criminal case, or was evidence about, say, an imminent threat to the public, I think your obligation as a citizen would be to act upon it. Where it gets cloudier is when police are looking for the media to basically do their legwork for them. And that's my assessment of what's going on here between the RCMP and Vice. And Greg is exactly right in that the courts don't see that relationship between reporters and their sources as sacrosanct. So it comes down to an ethical obligation that reporters may or may not feel. What the CAJ, the Canadian Association of Journalists, says is that you have that discussion with your source before you go into the sensitive discussion to say, okay, if I'm asked for this information, can I say where I got it from? And the source may say no. And then sort of the next level is, well, if we have a court order that compels us to turn over that information, can I turn it over? And if the source says no, or it's up then to the reporter to say, well, I can't risk I can't risk going to jail, or I don't have the money to defend myself, so maybe we don't talk about this then, because if I do get a court order, or if I am threatened with contempt of court or arrest, I'm going to have to give up my source. And that's the sort of thing, again, that we have to deal with. I've been lucky in my career. I've been asked, I'd say 2 or 3 times, once in criminal proceedings, but also in some quasi-judicial proceedings involving the Law Society and police disciplinary hearings, to reveal my sources. And our position was to say no. We were never brought to the point where we were served with a production order or subpoenaed, but obviously had to consider what was going to happen if that was the case. And my own feeling personally was that I had an obligation to these sources. I also felt from a self-interested standpoint that my career would be over if it ever got out there that a source who talked to me couldn't be protected. So I was quite willing to test it. Luckily, I never had to take it to that natural degree where I was facing jail, but as I said before, not a hypothetical question, one I considered and one I was going to go to the wall for.
And I suspect we'll be talking about this one too as this case moves forward. Gentlemen, really appreciate your time this evening. Thank you ever so kindly. Former Alberta Information and Privacy Commissioner Frank Work, defense lawyer Greg Dunn, and Jason van Rassel, journalist in residence at the U of C, Faculty of Law, as well as freelance crime and justice writer.